Hello, everyone, and welcome to Uncivil Law. I hope you're well, and I'm just waiting for my friend Nate to get his thing started. So I figured I'd join you because I didn't want to keep you waiting too long. Hope everyone's doing great today. I'm having a good day, and we're going to talk a little bit more about the without a crystal ball stuff, Toddy stuff. We'll take some questions because I know there's a lot of questions, a lot of confusion. So this will be a good opportunity for people to ask some Q&A about the without a crystal ball Toddy ongoing drama, which has become the Toddy without a crystal ball, Salts, Brown, Lori Ann, and Nat drama or something. The drama just continues to expand every moment. So we will see. But yeah, I lost Nate completely. Hopefully he'll join me and not keep me here. No, that's all right. I can improv a show if I have to, because I've got all that wonderful improv training, man. Yeah. So anyways, yeah, we're just going to be talking a little bit about the Parler lawsuit, talk a little bit of the Toddy without a crystal ball lawsuit. So first thing on the Parler lawsuit, pretty much panned out exactly like I thought it would. The judge denied the preliminary injunction. Not a huge surprise to me. That's basically what I said when I covered the original complaint and the response. The standard for a preliminary injunction is fairly high. You have to show 4 different things. You have to show likelihood of success on the merits. You have to show irreparable injury. You have to show what the harm to the other side would be, and you have to show what's in the public interest. And Parler basically was unable to satisfy any of those standards as it relates to that. So I'll just paraphrase some of the stuff the judge wrote in their opinion to talk about Parler, what was happening there, get that started. So on the breach of contract claim, because I think that was the most interesting, the judge had no trouble dismissing the Sherman Antitrust Act because there's no evidence of cooperation between the parties, or there was nothing submitted on that respect to show any alliance between the parties. So yeah, that was a total fail. And then there was the breach of contract, the intentional interference claim. Parler showed to show basic facts that would support elements. Fails to raise more than scant speculation. They're taken for improper purpose or improper means. Yeah, so that's a total fail for tortious interference, right? It may have caused interference with Parler's contracts, but it wasn't a tort, right? Amazon was using its contractual rights. So the fact that it disrupted Parler's contracts are immaterial because there's no tort. It might have been interference, but not a tortious interference. It sounds exactly right on the money there. So, and then so that was on the likelihood of success. And then on the contract claim, which the judge called the gravamen of the claim, which is the gist of the claim. It said, and then it just said basically what we said, that Parler has completely ignored section 72B2 of the contract. This is what we've been saying all along. Parler says we're entitled to 30 days notice under 72B1. And the judge writes exactly what we've all been saying. Parler has ignored 7B2, which allows this immediate thing. So therefore, there's no problem there. It hasn't even denied that it was in breach of the contract. Parler never denied it was in breach of contract. It just said it was entitled to 30 days notice. And the judge says, nope, no, you're not, because under 7B2, they can take that immediately. And that's a total fail. So, we could just stop writing at that point because there's no likelihood of success on it. And then in irreparable injury, it's just all speculative. For the serious questions going to merits and balance of hardships elements, in the balance of the equities, courts should pay particular regard to public consequences. It's therefore necessary. Follows that a claim does not support. Okay, Nate's giving me a call on my cell phone. Hold on one second. Hey, Nate. No, I've been Oh no, your camera. Yeah, your camera finally picked on. Okay, fair enough. All right, cool. I'll add you, man. All right, thanks. It's Nate the lawyer. Yay!
I've been sitting back here for like the last 6 minutes. I'm like, maybe he doesn't see me.
No, I haven't seen it because I saw every time I came back, your camera was off, and I saw you dipped out for a while. And I
Yeah.
was waiting for the noise to come back in my ear, so I missed it. I'm sorry. I was trying to improv a show while I was waiting for you.
No.
How you
You're
doing,
doing
Nate?
fine. I was watching the heart. I was like, oh, okay. But I was like, I don't think he sees me.
Nope,
I'm
didn't
fine,
notice.
bro.
It's like we'll take a phone call from Nate live on the air. Nate's like, can you let me on the stream? I'm like, yeah, we can do that. That sounds
Yeah.
like a good plan.
How's everybody doing out there in the YouTube world? Seems like
Oh
everybody's
man, we're doing
out there.
great. Yeah, we're just going through the elements from the Parler lawsuit real fast.
You
We
know what?
talked about go ahead.
You're talking about the likelihood of success of the marriage, right?
Yeah, we talked about that.
You know, one thing I think people fail to realize the procedural posture of this case. So to understand it, Parler first went for a TRO, a temporary restraining order, right? And with a temporary restraining order, it's ex parte. So the judge is only hearing one side of the story. So if you make a compelling enough story to the judge, they'll say, okay, we need to stop you right now from having from doing this, right? And that argument for the TRO doesn't seem to have convinced the judge, because the judge said, well, let's turn this into a preliminary injunction, which means both sides get a chance to tell the court why they should or should not, and we'll do it under the preliminary injunction. So I want Amazon to respond. So now Amazon's response. So to me, just looking at the procedural posture, it seemed that the judge wasn't really convinced for the TRO, and when it came to the preliminary injunction, the arguments that they put forward really just weren't enough to satisfy the immediacy and how important and how rare a preliminary injunction. The standard here is pretty high for a preliminary injunction.
Yeah. And as a practical matter, it's even higher for a TRO. It's the same 4-part standard, but it's viewed with more skepticism, because TROs, temporary restraining orders, are typically reviewed without any response from the other party. It's typically ex parte. Only one party is there asking for the TRO. So when only one party is there, the judge is obviously naturally very skeptical, because the other side isn't there to offer their side of the case. So as a practical matter, TROs tend to be issued only in the most blatantly extreme situations. They're very hard to get in civil case. The only time they're really somewhat common in civil cases is domestic violence, because there at least you have usually some sort of documented injury or documented threats that can be demonstrative, and you're giving the other side an opportunity to be heard shortly thereafter. So it's not typically viewed as much a problem there. But otherwise, in civil cases, TROs are really unusual. And the only other time that you'd see a TRO would be maybe for governmental action. So if there's some sort of like First Amendment violation that's going on from the government, so like the government was planning to disrupt a lawful protest, or was denying issuing a permit for a lawful reason, then you might see a TRO against the government where the judge says, yeah, you got to issue this thing, or you can't interfere with this thing because the First Amendment right is so high. So that might be the only other time that you'd really expect it. Otherwise, in a TRO, it's pretty rare to see it in a civil case.
Extremely rare, because you're either telling somebody they have to continue to do something they have a legal right not to do, or stop doing something they have a legal right to stop to do. Yeah. So it's an extraordinary remedy, and I think a lot of people, in going into the Parler case, Parler v. Amazon, thought it was not beyond a reasonable doubt, but the preponderance of the evidence standard, in which if they could show enough evidence, then the judge is going to issue a TRO, and it just doesn't work that way. You really have to show something extraordinary to get a TRO. And then even at the preliminary injunction stage, looking at the three main charges that they put forward, it just was there was just no concrete evidence. Like the argument for the first element. What was the first element? The first element was not the first
success.
Not for the element for the TRO, but the first cause of action. It was
the one that they did it. Yeah, it was antitrust. I'm not sure what order they actually did it in, but yeah, antitrust.
The first one was antitrust. They were doing it under the Sherman Act. And one of the more interesting parts of their argument was that they said, well, they have Twitter and they have us. Twitter has some of the same has some of the same content on Twitter as we did, right? So in other words, we had this bad content that breached our contract, but Twitter also has that same those same posts on Twitter, right? That was one of their main arguments. And because Yahoo or Amazon didn't do the same thing to Twitter. They didn't do the same action for the same conduct. They were treating Parler differently in this particular court. So, and they were saying that because, and the reason for that was because Amazon has a contract with Twitter, and since Amazon benefits off of the relationship they have with Twitter, then it was financial. They had a financial incentive to hurt Parler. So that was kind of the tangled web they weaved. But that argument altogether, to me, seemed like the cop in the speeder ticket. So let's say if I got somebody going 30 miles an hour over the speed limit and I stop you, I can do one of three things because that's reckless driving. I can give you a warning, right? I can issue you a ticket, or I can arrest you, right? Those are the three things I can do in that moment. But the cop, he may let one person go, right? This is your warning. He may arrest one person. But now let's say I arrest somebody. So that's what's happening with Amazon. Parler has admitted they breached, right? Parler said we breached this contract. So Amazon says, well, we have these two ways of dealing with this. We can either, give you 30 days to cure, or we can suspend it immediately. They chose to suspend it immediately. And just like in the cop example, the cop has the discretion. Just because the cop can arrest you doesn't mean he couldn't have given you a warning. The cop at that point, when you admit that you're in breach, when you admit that you drove over 30 miles an hour over the speed limit, you've now given that right to the person making that determination how to handle it. And that's what happened here. And so when people are saying that between Twitter and Amazon, that's some type of argument, it just is not. And that argument relies heavily, too, on what the contract is between Amazon and Twitter, because they can have a totally different contract unless you're assuming that they have the same exact contract as Parler. Because
which there's no reason to assume that.
Yeah, and their contract could be different. So based on just those two pieces of logic alone, then there's no way that Parler has demonstrated any type of monopolistic piece of this, nor have they haven't convinced the court that this was the reason, because they're assuming that Twitter has the same exact contract that Parler has, and that just may not be the case.
Yeah. And then on the contract breach element, the court just points out that the balance of hardships in the court's view tilts to Amazon's side because, Parler was hosting content that was problematic. Parler never disputed that they were in breach of contract. That was the thing, too. They never disputed they were in breach of contract. They just said that they were entitled to notice, the way that they wrote it. And they're like, no, you're not. If you're in violation of the contract, the way that's written, 7B2, if they can suspend you, they can terminate you. And they can suspend you if you're in breach of contract. So Amazon has all the options. They can suspend you. They can give you notice to cure. They cannot give you notice to cure. Amazon has all the cards, just like your police example. They could give you the warning for the taillight. They could give you the ticket for the taillight. There's a whole range of options that might be available. So yeah, it was dealer's choice, and they chose how about termination.
But some people are making the argument that because they chose to suspend immediately, then that gives no effect to the termination clause, and that's just not accurate. It's just because I arrest you doesn't mean I couldn't have warned you. You know what I'm saying? That's the reason why you have multiple ways of dealing with it. 7B2
means that 7B1 doesn't exist. I'm like, yes, it does. It's another option. I mean, either one will be fine. Amazon's choice. 7B1 or 7B2, dealer's choice.
As long as you and now, since they said if the best part would have been if Parler would have denied the breach, then you have more hope, right? But as soon as you say they breached, now you can't say, well, I don't like the way they treated the breach, because you're admitting you've already breached the contract. They get the choice. They get to choose which way they're going to deal with it.
Yeah, so it was a total non-starter at the start because we read the contract. We read it a couple times on stream. In fact, the last time we read it on stream, we read it 3 separate times in that one video just to make sure that we were reading it right. And we kept coming back to it just to make sure we were reading it right. And we're like, yep, we're reading it right. So there was no hope for breach of contract. So with all due respect to Viva or Barnes or anyone else who's analyzing this contract, all I can say is, well, I was right. Because it's like, I'm looking at this contract. I'm like, it's pretty wide open. It gives an amazing amount of latitude to Amazon, as you'd expect. Of course, why would you expect anything less? Of course, Amazon's going to write the contract in a way that's going to favor them as massively as possible. And you would just expect that. So Parler's, it's like, eh.
Yeah,
so, what's the right answer to that question?
If we have a breach, You could do one or two things. You could suspend it immediately if you think it's that
or you could
crazy.
ignore it. That's also another option because it's a breach towards Amazon, and
Yeah.
Amazon can always not care. So Amazon cannot care. They can give you notice. They can terminate you,
or they can suspend you immediately,
or they can suspend you. Yeah, they can choose not to care.
I bet
as a cop, there were probably some times when you saw the equivalent of a busted out tail light, and you're like, I can't even be bothered.
But
so not caring is a choice.
Yes, it's funny because I think when you give the example of the car, people understand that. Oh, okay, this is the reason why this is the that's the reason why, because you want to always give yourself options, and you would understand that Amazon, being in the type of services, was if something crazy was on, if Parler started doing something crazy, they would want the ability to take stuff down immediately. If things got too crazy, because they're hosting them, right? There's some responsibility to that too, and then also they would want where if you don't have the more serious things, then hey, you know what? Get 30 days to cure this. They take this one. This is not as serious, but we want to have the latitude to choose which way we're going to go. We just don't want to have to go one way. We want to be able to choose, and that's what happened here. They gave Amazon the choice. They signed a contract, and now they're saying, well, we don't want you to exercise 7B2. We just want you to exercise 7B1. And that just doesn't work that way. Absolutely true. Yeah, and there's a good question here from DIR. In a contract, though, aren't any ambiguities in favor of the party who did not write the contract? Yes, particularly in contracts of adhesion, which this is an example. So contract of adhesion is just a take it or leave it agreement. Amazon writes a contract. It's like you can accept it or not. We're not going to negotiate it, basically. So in a contract for adhesion in particular, you would read it against any ambiguity. You would read against Amazon. Unfortunately, there's just no ambiguity to read against Amazon. There wasn't an ambiguous term. They were all very clear. The terms were, we can do whatever the hell we want. So there's not a lot of ambiguity to resolve in favor of Parler. So yes, you would interpret any ambiguity in favor of Parler, but that doesn't suggest that there are ambiguities to interpret. So yeah. Well, it's one of the more interesting things is that I think it's weird how their first course of action, the antitrust thing, it fails, but then that failure also then rolls into the judge's reasoning for the second course of action, the contractual issue. And I think because those two failed, then you really had no hope on the last issue. The tortious interference with a contractual, what is it, business? Was it tortious interference of what? Tortious interference, right. So the idea there is that Amazon, by their actions, interfered with Parler's contracts, namely their contract between their users, because, of course, Parler has terms of service such as they are, and that's a contract too. So you've interfered with our contract with our customers. So there's interference, but you still need the other half of that, the tortious half of the equation. And the judge makes exactly the right decision. There's nothing here that suggests any tort by Amazon. First of all, breach of contract is not a tort. Breach of contract is not a tort. Breach of contract is not a tort. So there's that. Second of all, there's no suggestion from any ill motive from Amazon or any ill dealing. It's like, yeah, there were all these problems. We saw these problems. We took action in response to the Capitol because we think this kind of speech out there is really dangerous now. So that kind of changed our perspective radically. And the court's like, yep, works for me. So yeah, I mean, it's the right call. I'd have no problem reaching the same decision because, just applying the law, conservative or otherwise, a conservative judge should reach this opinion too. It's the right opinion. Yeah, I think that there are two issues here when a lot of people evaluate this particular case, and first is the free speech issue, right? Let's not ignore the elephant in the room. I do think there's a political motive behind this, behind the Parler thing. They could have easily given them the time to cure it and all that stuff, right? And obviously they're targeting Parler because it's more right wing and they want to get this stuff, and but they could have them go through all this stuff and remove the content that they want to remove, right? This is less, I think, about what was on Parler and more about what Parler kind of stands for in that way. And so if someone wants to make that argument, I agree with that, right? But I can't then take that reasoning and apply it to this legal standards that we have, because even if I agree with that, that doesn't mean they should have won this case because of the reasons that what we're saying. It's the law doesn't allow that to be the reason why this is going to go the way. Parler's not arguing that. Parler's arguing these technical legal reasons why they should win this preliminary injunction. And those reasons we believe are just insufficient for them to be granted this particular TRO.
So a good question here from Morgan Music. Forgive me if I missed it. I was in and out of the stream on civil illness. Were we looking at the user agreement for Amazon Web Services? We were. Wouldn't Twitter have to sign the same one? Well, you certainly would. You would be able to reasonably assume, but do they have to? No. I mean, they don't have to sign the same agreement. I mean, Twitter could come and be like, we want to negotiate a special agreement just for us. And Amazon could say, okay. So, I mean, you could assume it, but you wouldn't guarantee it. You know, there's nothing stopping Amazon from negotiating for a special contract for someone else. And so, yeah, maybe they did, maybe they didn't, but you couldn't necessarily automatically assume it. So, yeah, maybe Twitter has enough market power that Amazon would be willing to deal down and deal with Twitter, or maybe they want to because they're in a good mood that day or whatever. But yeah, you don't know for sure. That was our point.
Yeah, and also too, I would say it can go either way, and the reason why is because Twitter has different moderation controls for their platform, right? What we're going to do, what we're going to tab, we're going to take it off, that type of thing. And Parler doesn't have that, right? Parler goes out and says that we don't have this, right? We're going to be more open. So that could make a difference in where Twitter has a longer relationship, and because they already have controls in place that that align with Amazon, their contract may not have these provisions because they've had this relationship and they know they have these controls. Versus Parler, who is saying we don't have these controls. So you're kind of falling back on what if we have to watch you more carefully. There may be a different cost to that. But again, Parler didn't make that argument. If Parler knew that for a fact, I would suspect that would have been inside there. Parler and Twitter have the same exact agreement. And the reason why they didn't say that, because I don't think they knew. And if they didn't know, we can't assume it was.
And also Twitter's just not in the same position, because at the time of the breach, Amazon Web Services was not hosting Twitter's feed. They had a contract to do it at some point in the future, but it hadn't happened yet. So they were doing some back-end backup stuff relating to Twitter and some other things, but they weren't hosting the feed. So Twitter's feed can't possibly be in breach of Amazon's terms of service because they're not hosting them yet. They have an agreement to, but it hasn't actually matured. So the judge even points out they're not similarly situated. It's like, yeah, maybe Twitter's doing something, but they can't be in breach of contract because they aren't doing anything yet. So it's like the contract isn't actually in force in practice yet. So there's that.
Yeah, that's not only a little issue. That's it. That's kind of a big deal. Yeah. But we all came to the same conclusion. I know Nick was against it, but Nick is against it. I think more in theory of the whole First Amendment piece, the fact that it's more right leaning, and I think Viva all to the same. I think Barnes is he's saying technically they have a monopoly, but then one of the issues too, they didn't even identify the market, which we were talking about, to have a monopoly. Sure. You can say I have a monopoly, but what's the market? What's the area? How am I dominating? Yeah. Is it a natural monopoly versus an unnatural monopoly? And how are you making that? And
even having a monopoly isn't inherently illegal. It's only when you're doing anti-competitive things with that monopoly. Yeah, so it's not against the law to have a monopoly. It's only illegal to restrain trade. So you can have a monopoly. You just can't prevent other competitors from coming up and taking a piece of your business in a way that's unfair. So there's a difference there too. So even saying they're a monopoly doesn't solve the problem. It's like you still have to go to other steps of the analysis. Did they do something to restrain trade? What would those things be? That would be the restraints of trade. Do they actually have agreements with other people to act in concert? That would be great. If they had actual agreements, that would be very illegal. That would be a contract conspiracy in violation of the Sherman Antitrust Act. But short of that, it's like, what is Amazon doing to restrain your trade? It's like, we don't want to do business with it anymore. It's like, that's not fair. They're not allowed to not want to do business with us. It's like, yes, they are. Yeah. So that's what it is. But I think we need to move on to the topic probably everyone's here for, the ongoing and never-ending. Well, we should just call it the never-ending motion to dismiss, or because. Yeah, the never-ending Toddy Westbrook, Katie Joy Paulson, also Lori Ann Barnhart, also Michael Saltz, also Michael Brown, also Nate, whatever, Natalie, that girl, whatever her name is, and some other people. The May you, that is the ongoing whatever, continues to go on. The motion to dismiss has gone completely out of hand. That's why I made my thumbnail for the last video, the meme with the guy looking back at the girl he was with. It was personal jurisdiction, but he's looking back at T, because in this last motion filed by Brown, or this last paper filed by Brown, this last precipice, I don't think Toddy got mentioned by name at any point in the 200 plus pages. I'm not sure Toddy's name appeared once.
You know what?
I don't think the word jurisdiction appeared once.
You got to Control F that bad boy. Control F it and put type jurisdiction. Control F that bad boy type jurisdiction, because I got to see if it was mentioned one time. If it wasn't mentioned one time, then it's going to be like, what? Because
it's T. Because the T, man. It's all about T. We love T. Yeah, I'm going to open up these documents and see if those words appeared at any point. So we'll just do that while, yeah.
Well, hold on. So let me do this. Let me give the recap of the case while you bring up the documents. Okay, here is the recap. Toddy Westbrook, 9 million subscriber YouTube channel, big YouTuber, is suing Katie Joy Paulson without a crystal ball for defamation claim. Now, obviously, people have been served notice and all that stuff, and now we had a complaint. So we read the complaint. The complaint was good. It laid out all these defamatory claims. Myself and Kurt, we felt that it would be tough to survive a motion to dismiss for this, because there were a lot of things that Katie Joy could have said. For instance, she could have raised the fact that this was a public figure, and a lot of these defamatory statements seem to be opinions, and so forth and so forth and so forth. And the fact that she's a commentary channel, and they have even higher protections when it comes to things of public concern. So we said there's a lot of issues with this that's going to be easily attacked, and obviously a jurisdictional issue. The fact that she's in Minnesota and they're suing her in Washington. So these were the things that you would expect in a motion. Currently, with a 12B6,
12B 2, 3, and 6, I think, something like that.
Just the failure to state a claim and a couple of jurisdictional issues. Boom. So we get to the response. So the response really doesn't even attack defamation at all, right? It doesn't really attack defamation at all. And it really has like the first 7 pages of just facts that some of those were irrelevant. But it did attack jurisdiction, as any competent attorney would have attacked, because your client was in a whole different state.
I do like this one line from Brown, because jurisdiction didn't get mentioned 13 times apparently. But I do like this one sentence from Brown referring to Lorianne Barnhart, where Brown says, "This testimony is not credible, and more importantly, has nothing to do with personal jurisdiction or defense and lawsuit." Well, Mr. Brown, with all due respect, you're one to talk, because this also has very little to do with personal jurisdiction.
So now the complaint is filed, and Katie Joy, the response that we didn't really like the response, but we thought it had a winning moment. The winning moment is that personal jurisdiction. That seems to be the best issue.
Yeah.
So then after the personal jurisdiction thing came out, the response, now we get more just drama just happening within the file. So how many filings did we get after the filing? Now, generally, so we all understand with a motion to dismiss for jurisdiction, the standard that we're doing.
The issue we're actually trying to solve. What is the issue we're actually trying to solve? Let's refresh everyone's recollection, because we and the attorneys have long since forgotten. So what is the issue we're trying to actually solve right now?
Yeah. So the issue that we're looking at is whether the Washington court if it's fair for that Washington court to be able to pull Katie Joy Paulson from Minnesota and haul her into a Washington court and hold her liable for a tort that occurred. And the reason why is because generally, if you're going to sue someone, you have to sue them in a court that has jurisdiction over them, personal jurisdiction. And right now, the courts in Minnesota would be the place to sue Katie Joy Paulson. But they're saying we want to sue her in Washington. So the issue with personal jurisdiction is, has Katie Joy Paulson had enough contacts with Washington? In which Washington is in which a person who was doing the same thing Katie Joy was doing wouldn't be surprised if they were hauled into a Washington court. For instance, if I were selling a product to Washington, and if that product in Washington hurt someone, then it's reasonable to think if I'm selling stuff to physical products in Washington, if someone gets hurt from one of my products, that I could be sued in Washington. So that's the kind of minimum context test you're looking at. So that's where we're at. Now, with that standard, there's a way that you have to look at the evidence. And that way is if you take all the factual allegations as true, right? Take all the reasonable factual allegations as true. And you say, even if all this is true, does this court still have personal jurisdiction over this particular this defendant? I'm taking your allegations true. If they're true, does this person have does this court have personal jurisdiction? So generally, you wouldn't see an argument about what the facts are unless it's something crazy, right? You wouldn't really see an argument because you're really saying if all this is true, we'll see as a matter of law if this can still hold true.
Yeah.
So right now we're in the middle of an argument of facts that we shouldn't even be looking at.
Apparently we're in the issue of facts, which, last time I checked, Nate, in a motion to dismiss, you assume everything the other party says is true, which means in this situation, by law, you assume everything Toddy says is true. So you can't have a dispute over facts because only Toddy's side is taken as true. Who's telling the truth? Toddy is. It's real easy, super inconvenient. Who's telling the truth? Toddy's telling the truth. Done in one. Easy. But for some reason, anyway, we're still arguing over facts for some reason. Like, who lives where or who did what to when, and is Lori Ann work for this agency or that agency, and did Michael Brown do this thing or that thing? It's like no one cares at this point about the facts because, again, everything Toddy says at this point is definitionally true. That's the entire point.
It's true. Are you sure? Are you sure it's true? It's true. Yeah, I'm talking because right now that's exactly what's being challenged.
Yep.
Everything this woman just said wasn't true. That's the whole thing that they've been saying, right?
No, I think we've long since lost the plot on the whole thing, man. It's like, did you guys forget how a motion to dismiss works? Michael Brown, in the response that he gave to the motion to dismiss, his response included an affidavit from Katie. Why? Because Katie can only possibly contradict facts. That's all she can do. I mean, as a practical matter, is offer facts. Her attorney can argue law, but all she can offer is facts. But none of her facts matter because we, again, just sue. Katie's saying that's not true, and I'm the court. I'm like, la 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 la. I'm not hearing you. La 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 la. Nothing you says matters. La 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 la. Everything Toddy says is true. Why are we doing this? But yeah, we're having this huge factual dispute.
No, hold on. But just so people can understand, these things can be challenged later, right? If you're saying, well, these things are false, you can still challenge. You can bring in evidence and say, no.
Oh yeah, no, we can argue. We can argue facts later.
Yeah, it's not true.
It's not like that once we said it now, this will be true for all of time.
Yeah.
No, that's not how that works. We as lawyers are doing what we call assuming arguenda. Means assuming for the sake of argument, this is true. Then here is the results that would follow. So what Michael Brown's response should have looked like in an ideal world, right? What his response to the motion to dismiss should have looked like is assuming every word Toddy says is true. We don't have liability. Here's why we don't have liability as a matter of law. As a matter of law. Not as a matter of facts, but as a matter of law. Because yes, even if we did all those things, we're still not responsible and you can't get money from us. Nah. That's what the response should have looked like, but not so much.
This may help people understand it better. This same standard is used to evaluate claims of statute of limitations. So let's say the statute of limitations is a year on something and someone files it 2 years after the statute of limitations ends. It wouldn't matter what the underlying facts of the claim are, right? The underlying facts of the claim don't matter. That person could have technically been defamed per se, all of it, right? You have the best defamation suit. The only issue is you waited too long. The statute of limitations is run. So in that case, the court will say in a motion to dismiss for failure to state a claim or for the statute of limitations to run, the court will say, well, we're going to assume everything the plaintiff is saying is true, right? Because it doesn't matter. It doesn't matter what they're saying. What does matter is when they filed it, right? This happened when and when they filed it. And that's why we don't care about the facts. That's why we don't care about an argument between the facts. Because at the end of the day, it's as a matter of law when this claim start and when were you supposed to file. That's it. And that's the standard that this motion to dismiss seems to have failed to understood, is that the facts don't matter. We're talking about these things as a matter of law.
Can the judge draw this out without prejudice? Yes, and that's almost certainly the result that will happen, not for least the reasons that Brown didn't move to dismiss all the causes of action in the motion to dismiss. So there is one live cause of action, the defamation, which is the principal cause of action, incidentally. So a dismissal with prejudice wouldn't really make sense at this point because there's a live cause of action. So dismissal without prejudice, if the judge doesn't find jurisdiction, would be the most logical thing to occur. Dismissal with prejudice seems impossible unless the judge really wants to hammer it home to one of the parties because, I don't know, of malfeasance before the court or something. That'd be hilarious. So unless the judge really wants to penalize Toddy for I don't know what, but that would be the only way that would happen. I'm going to put with prejudice as a sanction. That'd be good.
But hold on. I would say it's so well, yeah. Based on jurisdiction, it would be impossible to find it with prejudice, right? Because you didn't have you didn't have the authority to hear the claim. So how can you lock anybody else from hearing the claim? Then no one else can ever actually the proper court of jurisdiction can't hear the claim because now you've closed it with prejudice. So I don't think that's even available in that particular scenario. But I do think it would have been available if you argue the defamation. Yeah. Then you could argue that as a matter of law. They can have, as a matter of law.
So one, I don't have jurisdiction, and two, even if I did, I'm dismissing it with prejudice because there's nothing here.
Exactly. That may have made more sense.
That'd be good. Yeah, even though I don't have jurisdiction, dismissal with prejudice anyway. I'm like, that'd be good. Yeah, but that's not going to happen now.
No.
So yeah, and you better hope that there's a plan somewhere. Do you think all these filings are really because both sides know they'll be discussed and will help both their sides keep the subs and income? I mean, Toddy isn't making any videos now, right? So I don't think it's helping Toddy because she's not making any content. Katie, is it helping her? I guess, but assuming that she's held liable, she's not going to make enough income to make this all okay. So yeah,
no, but let's even though. I think because we both said this was going to be a hard case for Toddy, but one thing that makes hard cases easier is when I think the legal strategy isn't really clear on one side, and I think that's what's going to happen now is that they're arguing about these tits for tats about who's right about this or that. It's really irrelevant. We need to focus in on how to win the case. We want to win the case. That would be good.
That would be good. What if we focused on actually, winning the case instead of tea? Because the last couple things have just been nothing but tea. There's been salt tea and there's been brown tea. So you get to choose what flavor of tea you like. But yeah, anything actually like regarding the case, I think we've long since forgotten about. The attorneys are now arguably in a bigger fight amongst themselves than Toddy or Katie ever were. because it's you just see these attorneys slapping at each other, and it's becoming very unseemly for the bar. We're supposed to be better than this, Nate. We're supposed to be professionals, and it's become very unseemly. So the drama has definitely rubbed off on Salts and Brown. So it's like I'll say what I said before. So it's like I don't know if Katie Joy might be watching this somewhere. So it's like here's my suggestion. Someone needs to call someone. Someone's attorney needs to call someone else's attorney, and they need to have a little kumbaya session and calm everything down because this is well out of control. It's not helping Katie. It's not helping Toddy. It's just becoming a shit show. That's not helping anybody. So, like, someone needs to call someone and try to put this thing back on the tracks. As a member of the bar, I'm begging you, please. We can do it. I believe in you guys.
Yeah, I think this has gotten this is. I think there's two wars going on here: the war of public opinion and the case file. But now they're merged into this one big conglomerate, right? Where the case file is actually driving, because a lot of the stuff that's in these case files now is for public consumption, and to convince us that one side is right or not. And since we're consuming it, these briefs seem to be more written for us than they are for the legal issue. Because again, for the legal issue, it doesn't matter because we assume what the plaintiff is saying is true.
Yeah. And I mean, I ultimately don't know what the right legal answer is because I have to get really down into the weeds on personal jurisdiction in the Ninth Circuit and go look up some actual case law. So if I were the judge, right, I have to actually go read some case law to figure out what the right answer is in this situation and try to figure out but yeah, whether or not Lori Ann lied even in her affidavit, it's like, I can't be bothered to care if I'm the judge. And that's one of the great things as judge, because I can this is what I'd be like. Yeah, I'm like, yeah, a lot of these filings have been super interesting and all, but I'm basically ignoring most of them because I'm trying to solve a personal jurisdiction issue. And I knew all I need to know a couple filings ago. I've got it. You know, I understand the issues. You know, Katie's been making a whole bunch of videos. She's been making them about the Westbrooks and Halo Beauty. The Halo Beauty is based in Washington. The Westbrooks, at least according to them, live in Washington. Remember, we're assuming what they say is true. So they live in Washington. So, okay. So does that mean that she purposely and she maybe did some research in Washington? Is all that enough to have personal jurisdiction over Katie? I'm like, yeah, got it. I understand the issue. Got it. Please stop filing things. I'm going to go off and do some case law research now and figure out what the answer to the question is, and then I'll let you guys know.
Remember in the motion to dismiss response, there was one piece of it that confused me, is that Katie mentioned that Toddy was really living in California and not Washington, you know, for this. And that never seemed like, I was wondering, why would her lawyer put that in the document? Now, unless you're trying to show that, you know, somehow it's relevant to her, to her, I don't want to say to her level of truthfulness in the file, it just seemed irrelevant because it doesn't matter where the plaintiff lives, right? The plaintiff can file suit in Alaska if the plaintiff wants to.
Right.
It's whether that court has jurisdiction over the defendant that matters.
Right.
So the argument that Toddy was really living in California and not Washington, that didn't matter. And that's why when we hammered the motion to dismiss, those were things that we're talking about. It's like, why are you arguing things? Why are you fighting with facts that don't matter in a legal context? Because even if she lived in New York and she filed her case in Washington, it doesn't matter to the personal jurisdictional question.
Yep.
Of whether this court has jurisdiction over the defendant.
Yeah, absolutely. And for those of you guys asking if the trial will be broadcast or not, I want you guys to know, because I'm the best on civil law, I have emailed the court. Really, I have emailed the court and asked whether or not the hearing will be available on Zoom or not. And I even asked whether or not I can have permission to rebroadcast the hearing. And I haven't heard back from the court yet, so I'm looking into it. But I'm trying. So yeah, if there's a hearing and we're able to listen in, then either one, if I'm not allowed to rebroadcast it, then I guess maybe I'll just vocally transcribe the entire hearing while I'm listening to it, so you won't be able to hear their voices, but I could just repeat what they're saying. Maybe that'd be good. Or maybe I'll discuss what I'm listening to, and you guys will just have to pretend in between. But yeah, but I did email the court. I'll let you guys know. But I'm on it. I'm on civil law. We might have tea on the 1st. I don't know. We'll see. Maybe a week from Monday. We'll see.
That'll be a lot. They're probably doing it through Zoom too. So
yeah, no, probably, almost certainly. Yeah. I mean, they're not meeting in person, so it's either going to be Zoom or on the telephone. It's like, so I emailed the court. It's like, psst, can I get some of that telephone access? And also, can I rebroadcast it, please?
Oh yeah, I remember the last time.
The court's not going to say yes to. The court is definitely not going to say yes to. Can I rebroadcast it? I know they're not going to say yes, but at least I can ask.
But why not though? It almost.
I don't know, because reasons. I don't know. I mean, why won't they do it? I don't know. But courts are just anal about this kind of thing for some reason. You know, I got into trouble with that, with the whole Sullivan thing. It's like, I'm not going to make that mistake again. You know?
But ask for permission. Ask, yes. The thing is that Now, hold on. I do want to understand one thing about this case is that this whole issue now that we're talking about now, what they're filing about now. So Lorianne says, so the whole issue is Toddy said that Katie had minimum contacts, right? Because of whatever issue she said. So now, from my understanding, Katie is challenging the truthfulness of Lorianne's statements.
Yeah. They're all challenging this truthfulness, and there's a lot of evidence to challenge it. Lorianne's credibility as a witness has kind of gone to zero because her affidavit is well inconsistent with the statement that she gave to Brown. And that may not be under oath, but it's absolutely impeaching material. And this is where a point where I and Emily disagreed. Like, Emily thought that the affidavits Brown wrote have no evidentiary value because they're not signed. I'm like, that's kind of true. They don't have evidentiary value in and of themselves in some respect, but how Lorianne reacted to them, right, is material, because if they were completely false and she said, no, these are completely false, they don't represent my view, what are you not paying attention to, right? That would be one thing. And she says, no, these are basically right, but I'd like to make these changes, right? Her conduct or her words can basically validate it in some way. So yeah, the fact that they're not signed, I mean, it's not the same as a sworn declaration. That's true, but her reaction to it is material, and we have all those emails. So like Lorianne's value as a witness has gone to zero. This is a good question too. Didn't the last filing by Brown just ask the judge to take action, give jurisdiction? Emily and I have a disagreement of opinion on this, and I was trying to look into this a little bit to find out which of us is right. And again, this isn't like a beef between me and Emily. All right, I like Emily very much. People seem to keep trying to start beefs or something. It's not going to happen. But yeah, we have a disagreement of legal opinion. So Emily's of the opinion that Brown asking for the status conference is asking for the judge to do something and therefore waives the personal jurisdiction issue, because how can the judge do something if they don't have jurisdiction? That's Emily's argument. My argument is they have to have jurisdiction enough to decide whether or not they have jurisdiction. There's something inescapable about that, right? So the whole point of the motion to dismiss is to decide whether or not there is jurisdiction. So you have to have jurisdiction enough to decide whether or not you have jurisdiction, right? There's some irreducible thing to that. And so my view is the status conference, in light of the motion to dismiss, which is ostensibly over, at least theoretically at this point, because we're within that chain. My view is that the request from status conference by Brown does not amount to a waiver of personal jurisdiction on the court of Brown. And I did a little bit of research on the case law on this and Westlaw, looked for about 25 minutes. I couldn't find any case exactly on point either way. Now, that isn't to say there isn't a case on point either way. I just wasn't able to find one in 25 minutes worth of working. But my view is those federal rules allow for status conference by their own terms at any stage of the proceedings. So I don't think a status conference within the motion to dismiss by Brown defeats or waives the personal jurisdiction. That's my view. Emily seems to disagree. Maybe we'll find out which of us is right, depending on what the judge does or does not write and or cite. So we'll find out.
Waiving personal jurisdiction by asking for a status conference on a motion to dismiss for personal jurisdiction. Yeah. It's just going to be hard for. I think it's going to be hard. It's going to be hard to justify an appeal, because that's where we're at, right? All of this is going in to a motion to dismiss for personal jurisdiction, and we're asking for a status conference about that motion to dismiss, right?
Yeah.
So I
mean, theoretically, right? I mean, because all these precipes are theoretically part of the motion to dismiss. Somehow, I mean, they must be, because what else could they be part of?
Maybe because I would understand answering the lawsuit would possibly give you yes, okay, the person answered the lawsuit, so they are, but if you've asked for the motion to dismiss and you're at that stage, then I don't know anything in furtherance of that cause of view.
Yeah,
because you could even make the argument that then putting in the motion to dismiss gave the court jurisdiction, right? Because why you responded if the court
exactly, because the motion to dismiss is asking the judge to make a judgment about whether or not they have jurisdiction. So there's something irreducible in that you can't get past. But yeah, we'll see if the judge makes a decision. The ideal situation if the judge like says that there's a waiver would be if the judge actually cites relevant case law so that we can go look it up and see if it's right. Because if the judge just makes up something, then I can still disagree with the judge, at least. It'd be like, well, maybe this judge is wrong. So the ideal situation would be if the judge says somehow it waived jurisdiction, the judge cites some sort of binding authority for that, and we'll go from there. So, yeah.
Yeah, I still think, even on the jurisdictional claim, I think that's really what they're hanging their hat on, right? If they don't, this is like the coup d'etat of the case.
Yeah, we have a lot. We have quite a few documents to decide whether or not there's jurisdiction at this point.
So if my understanding of the law, it seems like it's a toss up, but if there is jurisdiction, hold on, I got somebody at my door. Go ahead. I'll be right back.
Okay. All right. Well, I guess it's just me and Nate because Nate's talking to someone at the door. But yeah, we'll see if the judge cites something specifically on point. And maybe there's a specific case out there that would say it. The best I've been able to find is that if you get into the merits of the lawsuit, so if you start trying to argue the merits, that you might have a problem. But I don't think that's what's happened, and I definitely don't think the request for a stats conference is a merits-based thing. So that's my best understanding of what the case law seems to suggest.
Yeah, it has to be. If you're asking, I don't see how this would confer jurisdiction to status conference. But I think the court should just say, all right, enough. Nothing else on this motion to dismiss. We're done here. I have enough to figure out where we're at with this motion to dismiss. But I think Katie has. I think if I was a betting person, which I am, I would actually give 2-1 odds for Katie. And the reason why is for a couple of reasons. Number one, it's hard when you're suing someone out of state, and the minimal context test is not something that's easily overcome. It's something that you really have to show. And if the argument, it seems their argument was twofold. One, that she was getting all this information from, she's getting all this information from the state, the documents or whatever. And the second was that she was getting revenue from the state, right? But if we even take those two things as true, then it seems like in one instance, if the court says, okay, just because you have this contact with what's her name? What's her name? Lorianne, and she super chatted you. That's the reason why this state has jurisdiction over you in Minnesota. That means that every super chat that you got today, and every super chat that you got from the beginning of time gives that state or that jurisdiction over you personally, right? So we're talking about if people are super chatting you from the Virgin Islands, if people are super chatting you from Puerto Rico, if people are super chatting you from Florida, they can technically, it's by their theory, seems to be able to say they can sue you in their own court, right? You got to go to them. That would just make personal jurisdiction so fluid, where it seems like the concept would almost disappear for people who are on YouTube. Every YouTuber who gets a super chat or some experience from somebody from any one of, there's only 50 states, right? And what happens if you got 22,000 subscribers? Do you think you've touched each state?
Yeah, no, that's exactly what that's exactly what my argument was. And that was where I thought Brown was brilliant, because he was basically echoing exactly what I thought. Like the argument for me, if I'm Brown, is of course we have subscribers everywhere. Of course we get super chats from everywhere. Of course we have viewers from everywhere. Of course we get revenue from Washington and everywhere. There's nothing undifferentiated about this treatment. There's nothing targeting Washington. So the fact that we have a Lori Ann, the fact that we have super chats, the fact that a couple times someone said they're from Washington, my response as Brown is, who cares? No one cares. No one cares is my answer to that. It's like, yeah, we had that, and we also had a couple people from Puerto Rico. Can you sue us in Puerto Rico? What the hell are you talking about? So, that's basically what I thought. And that's what, when we saw that in his response, I'm like, well, this is brilliant, because that's basically what I would thought. So I don't know if he's taking notes or something, but it's like, that's right on the money. That's the best argument you have. None of it matters. It's all the same. Who cares?
Yeah, and you say, okay, yeah, whatever Lorianne says is true. Whatever she says is true. It doesn't matter, right? It doesn't matter, because I have these type of contexts everywhere. And it just would be absurd to make it so all these places have personal jurisdiction over me because someone sends me a $2 super chat. And the rule is, is what you would reasonably, would it be, because the rules is about fairness, would someone fairly think that because someone sent you $1 super chat that a court in Guam could hold me personally, liable for something? Just doesn't make any sense.
Welcome to jurisdiction from Denmark. That's what I'm saying, man. It's like if me having super chats, man, I can be sued in Japan. I can be sued in Australia. I've got viewers from Australia. Apparently, I can be sued in Australia now. This is some BS, man. Which is why I said, and I said this on stream last time, it's like ideally as a judge, I'd like to rule for Katie if I can. Now, again, as a judge, I can't always do what I like. And Scalia said that, a judge who always rules the way they like probably isn't a very good judge. I'm like, yeah, sometimes you can't reach the decision you want. So I'd have to go research the case law and see what it does or does not allow for. But I think the case law is probably open enough to give me enough latitude to make a decision one way or another. But I don't know that for sure. But yeah, if the case law compelled me to rule for Toddy, I'd do it. Of course I would. I'm a good judge. I will do what the law requires, even if I don't want to. I might hate myself a little, but that is what I signed up for. So it's all okay.
Can I see?
I'll take super chats from everywhere. We got $35 from super chat me your money from literally all the countries and states, and we'll see how that goes for my future liability things. Like, this is ridiculous, right? Yeah.
You got Puerto Rico, you got Hawaii. We
got Guam, man. Don't sleep on Guam, man. Represent the Guam. What?
It's got to be like a 50-cent super chat or $1 super chat. That gets
That's right. Yeah. Donate $2 and your country too can be represented. Oh man, yeah. So the whole thing is messed up. But the fact that this thing has been going on so long and we got so much tea. Let me just recite. Let me just go look up in the docket again and recite all the things that we have got from since the motion to dismiss, right?
You got a member from Alabama.
How long has this been going on?
Yeah, you know what? This is what happens, I think. Soltze, I'm not sure if Soltze just hired to win this case or Soltze being hired to do something else, because Soltze, I understand you get these people online, you start talking to people, you get these great affidavits. I think you with the complaint alone, I think he's already won the game outside the courtroom, right? That was a brilliant piece of writing. I followed it. Now it's interesting because I think if you look at it critically, some of those statements were just opinions. Some of those statements she can back up. She's like, I looked here and I saw this, and the standards of which it is to win a defamation suit, I saw flaws. I thought it was a great. It's just like the Texas going up to the Supreme Court. I thought that case was beautifully written, but I thought it was thrown out.
As a matter of legal writing, the case that Texas filed against Georgia in the Supreme Court was brilliant.
Yeah, it was beautiful.
It was brilliant. It's some of the best legal writing I think I've ever seen ever. I mean, it was unbelievable. Not that you'd expect less before the United States Supreme Court, but like, I know I can't do that. I can't even come close to doing that, Nate.
But they were wrong.
I don't have that ability. And I'm looking at this. I'm like, oh my God, this is a work of art. Now it's all bullshit. I know it's bullshit, but it still can recognize it as a work of art. I mean, it was unbelievable.
Yeah, no, I'm with you, brother. I thought they were wrong, and I thought they were going to lose. I thought they didn't have any standing, and that's what came to pass. And that is, and that's what I'm trying to say is that Soltze did more than enough with the complaint alone. And then even the response, because you would suspect in a case like this, you'd have a complaint, the motion to dismiss, and then you'd have the response, right, to the motion to dismiss, right? And that'd probably pretty much be it. And I thought the response to the motion to dismiss gave Soltze that other shot within the realm of, regular stuff. All right, I respond to the motion to dismiss, whatever. Yeah. But now we're at the point in time where if you're not mentioning motion to dismiss, and this is the reason why I'm filing this is for a motion to dismiss.
Big Sky, baby. Big Sky from Montana. Got to get some representation from Big Sky. That's a nice photo, by the way. I don't know if that's you, but that looks great.
So I as of right now, the Lorianne stuff is technically, do you think it's irrelevant or not? Because I'm under the impression
pretty irrelevant.
The only
thing that I thought, the only thing that matters there in the Lorian stuff is that the judge really wants to latch onto the agency theory. Now, the agency theory didn't really do much for me, but before that, I had 60-40 for Toddy. So I bumped it up to 65-35. It was like, well, maybe the judge will really latch on. I don't think the agency theory does anything. It doesn't do anything for me. But maybe the judge disagrees, and maybe he really latches onto it, and he could base an entire opinion around that, if nothing else. So it's like, if the judge really goes for the agency thing, then that could be a thing. So I'll bump it up to 65-35. I don't think it matters, but I could see the judge latching onto it and running.
Oh, so you think Toddy's going to win the motion to dismiss?
My prediction is that the judge is going to rule that there's jurisdiction. Yes.
Oh, wow.
Yeah.
See,
my prediction.
I'm 60-40 the other way. Actually, I'm probably like 70-30 the other way. And the reason why is I just don't think I don't think they have enough for personal jurisdiction. I just don't think they have enough, because you're
it's a female judge. I keep making that mistake. I am so sorry. I do keep making that mistake, Bunny. I'm really sorry. And I shouldn't do that. I apologize. It is a female judge. She. No, that's my fault. I do that all the time. I should know better. It's my bad.
Yes, we definitely apologize. I'll just refer to her, the judge. I think the judge in this case, but the judge in this case, it's just hard to get that because of the way, I think you're right. If the judge focuses in on agency, I think you may have something, but then you also have to talk about, is it reasonable, to say that if I say somebody to do something on Twitter, that means that she's my agent, and, Washington, there's just not enough. Now agency, I'm suspecting, is I'm paying you to do something in Washington, right? So if something happens, then I have an interest in what happens between you and Washington. I don't see that here, And at the end of the day, if I think Toddy wins jurisdiction, it won't be because it's his great argument. I think it's just because the defense didn't do enough to say, hey, this is about whether it's fair to hold this defendant from Minnesota to Washington to be sued, because this woman super chatted her $2 because she looked in a database and saw these documents. And don't forget, it's also saying that there would have been enough where a reasonable person would have thought that their actions was causing them to be sued in those other jurisdictions.
Yeah, I think that's right. And I totally understand what you're saying. The thing that's sort of biasing me the other way as a huge factor is that most judges like to have jurisdiction. They tend to think, most judges have a well-earned ego and well-earned God complex. Is like, I can decide all the things. So I think your analysis makes sense. I'm not sure if you factored in the I am God and I will decide all the things factor in this equation when you're scoring it, though. So that's where I'm kind of predicting the other way. But I think Katie Joy has possibilities. And for the answer to where you would sue, the answer is easy: Minnesota. I mean, that's where Katie Joy Paulson lives. So if you always have jurisdiction where the person lives, that's an easy one. So if Toddy wants to sue Katie Joy Paulson, she can always file in Minnesota. No problem, no questions asked, easy peasy. Now, whether or not she can win is a whole nother set of problems, but jurisdiction's easy because she lives there. So that's easy enough.
And let's say, because a lot of people get confused by this, let's say the tort actually occurred in Washington and Toddy and them sued in Minnesota. They wouldn't actually use Minnesota law for the claim. They would actually use Washington law.
Even if this is filed in Minnesota, Nate's right. Even if this is filed in Minnesota, there's a very good chance Washington law will apply, even if it's filed in Minnesota, because a lot of these torts may have occurred. I mean, that's where the damage is. So Washington law may ultimately apply, even if this is heard by a Minnesota court. But the question is, which court's going to hear this? So, Nate's right. Which law we'll hear under depends.
But that's why, and that's why I think it was such a mistake not to attack defamation in this motion to dismiss on the 12B6. The reason why is that the attacking the defamation claim is only a second bite at the dismissal apple if jurisdiction doesn't work, right? Because let's say jurisdiction does work. then you still have a naked defamation claim out there that hasn't been challenged in the motion to dismiss. So in that sense, you have the Tucker Carlson case, you got the Rachel Maddow's case. Those are your first two cases.
Right.
And in those cases, you say my channel is a commentary channel, just like
Right.
Rachel Maddow's is, just like Tucker Carlson is, just like, and then you go pull up some YouTube cases, some of those light YouTube cases. Here are some other cases where YouTubers are commentaries and they were sued. And this is what the court said. And then you say, then you make the argument that even if everything that Tati has said is true, motion to dismiss standard, she's a public figure and we can't sue her. And on top of that, these aren't actionable because just like in Sandman, remember each statement they went through. This is not actionable because it's an opinion. This one's an opinion. This one has a reasonable basis of belief. Here it is. He was sued in a lawsuit, and guess what the guy won? Boom, that's where I got that from. This way I got that from. Reasonable basis for this one. Reasonable basis for this one. I don't even think reading that you could actually even take negligence out of that if you just go through each one of them.
No, and I think Toddy has kind of ridden Katie's response to even James Westbrook, because James may or may not be a public figure. He's appeared in a lot of Toddy's videos, but let's just assume that he's a private figure. All right, so let's just assume he's a private figure. If he's a private figure, you need to prove negligence. That's the lower standard, right? Public figure, you need to show malice to the truth. For a private figure, you need to show negligence. But their own civil harassment claim helps to undermine that, because part of the civil harassment claim from Toddy and James has been, well, they were pulling up all these records. They were investigating our family. They're looking for birth certificates, looking for death certificates. They're pulling records of where we live, all the rest of it. Look at how much stuff they're doing. And as Katie's lawyers, my response is, we did all that stuff. That goes to show exactly how we're not negligent. Look at all the research we did. We pulled birth records. We pulled death records. We pulled family records. We pulled living records. We pulled so many records. And even if we made a mistake, right? And even if we said something false, so we'll go to the next step. Even if we said something false, how can we possibly be negligent? Look at all the wonderful research we did. What more could you possibly want from us? That's what I want to do if I'm Brown. It's like you can't even make negligence because the very things you said we did, of course we did it all. That's exactly why we're not negligent.
That's exactly what you're supposed to do at a motion to dismiss.
Yeah. No, that's why I beat my head against the wall and banged my head against the wall. I kind of want to do it again now, just thinking about it.
What
I want to go bang my head against the wall
I did all this
right
research.
now because I'm just thinking about it because I'm like, oh my God, you can beat. First of all, you've got public figure against Toddy without breaking a sweat. You've got public figure against company without breaking a sweat. You've got an arguable public figure for James. And even if not, how can we possibly make negligence? Because we did all this wonderful research. See how much research we did? We did so much research. How can we possibly be negligent? I'm going to bang my head against the wall because, oh my God, I can win this negligence claim. I can win the defamation claim if I'm Katie. If I make the defamation claim disappear, if I make the defamation claim disappear, I can make everything disappear. I'm like, I can't. Oh, why? Why did you move this the defamation? Why?
Well, hold on. It's still he still has the motion for summary judgment that's just come up. Right after all the stuff comes in, then you got the motion for summary judgment. Direct, boom, it's all over. So at the end, she can still win if now, but now if the good thing about it, if she wins on the matter of fact, I forgot to mention it earlier. The one thing about while we are so upset of why they didn't attack the defamation in this motion to dismiss, is because if the judge rules on the underlying claim, then that's good. Then she can't bring that anywhere else, right? Motion to dismiss because guess what? You haven't met the elements for the claim. So if they do it on the merits, then she can't bring this back up, right? She failed to state a claim. That motion to dismiss is that now her claim is done. Yeah. But if you lose it if you lose it just to jurisdiction, she can now go file it in a proper jurisdiction. If you lose it on the merits, then that's over. The claim is over. The judge is saying everything you're saying is true. You lose anyway because you're wrong on the law. Maybe that's part of the grand plan, Nate. We want to force them to file in Minnesota just so we can bring our real A game and just destroy them in Minnesota to show how awesome we are. Now, I think Toddy has some chances there
So
All right.
I don't
Hold on,
want to
yeah.
sell this as a complete slam dunk, but I think Katie missed some very obvious opportunities that are a little frustrating.
Oh yeah.
It's like Toddy has answers to this that are workable. So Toddy could win this thing for sure. And as Emily herself points out, this is a very fair point, right? If Toddy wins on even one cause of action, and there's quite a lot of them because there's quite a lot of videos.
Mhm.
Toddy wins on even one cause of action, she could get some fairly serious damages. So Katie has to win on them all. But I'm like, I've said this to you before. If I had to pick a side between them, it's like I want Katie's side of the argument because I think I could win it. I think I could win.
I honestly think. Well, to be honest with you,
I know I'm behind, but still,
just let's honestly just talk about for Toddy, for the public figure stuff and the company. I think those claims are done. I don't think you get anything out of those claims, right? For those two, for Toddy and I think those claims were just the tea to throw it out there. You know, you throw it out there and you play a little game, but I believe their lawyer knows those claims are nothing. They're garbage. But I do think the James claims, I think that's where your fight is. I think because you had the fight for the public figure.
James has the best opportunities. James has the best opportunities.
And so I think your fight is with James.
Katie said some really shady shit against James in particular.
Yes.
For the emotional interference, not so much against Toddy, but going after James and saying, "You killed your mother because you wanted the life insurance," which is, as I understand it, essentially what Katie did. It's like, or at least implied, or at least that's the argument from Toddy's or James' side. It's like you insinuated, if didn't outright say, that I killed my mother for the life insurance money. That's pretty horrible. I'm like, yeah, that's pretty bad. So James has a better position here.
Yeah, I think if you're just evaluating the course of action, how it would go, because I think the first two go under actual malice. I think they're gone. Boom. And I think James' claim, if they find him to be the public figure, now the evidence they got for him to be a public figure, I think it's substantial. You know, businessman. He's on this channel. He's he's got these high level business deals. You know, he's being sued for the company. You know, he's running one of the best beauty companies on YouTube, and he's married to this woman, and he's appearing in all her videos. Right? People know who this guy is. Right? Public figure is not an easy win for James, right? But let's say he gets out of public figure, which I think is not a win. It's not something I would put my house
not a
on.
win. It's not a win.
Yeah.
It's not guaranteed.
Yeah. So let's say he loses that, and we're down to negligence.
Yeah.
Then just accepting everything the plaintiff has said is true. I've done all this research, right? I've looked at family records. I did this. I did this. I did that. I did all this stuff.
I scour their lives, man.
Yes. And here's exactly what I found. Now,
yeah,
I agree with what they're saying. I did all this research and still said these things. So a reasonable person, right, would have done the research, and when they did the research, they'd be able to make these claims. So it's now, have you proven she was negligent? No, by their own admission. They're saying she wasn't. Matter of fact, they're saying she was doing so much. It was becoming abusive, right? She's looking into everything. Yep. Right? She's looking into everything.
Yeah, that's exactly like their own civil harassment claim works away. And James has his own problems too, like also because James had that default judgment against him, which was later withdrawn, but it exists that he was the default judgment for fraud on a business and for other things, and he has some problems in his history. So it's like I can still win there too. It's like, yeah, I looked at all this, and it's like, yeah, in my opinion, he did these things for this reason. That's an opinion statement, maybe rather than a factual claim. So I think Katie has a interesting position.
But then
I've kind of said this in a perfectly argued case. It's like I'm trying to battle this in my mind, but like in a perfectly argued case, I think Katie is favored. Of course, in the motion to dismiss, we saw less than perfectly argued, which is again why I beat my head against the wall, because I was very, very frustrated. Because I'm like, you are listing some very obvious things that I think are very good for you that would probably tip the scales in your favor. Why are you doing this? Why are you making me so sad?
Yeah, it's I at this point in time now, I think if you're a betting person, you got to bet on Toddy's side. I think has had the more professional filings. A lawyer seems to be, a lot sharper than the lawyer on the other side. And, and it seems like he's really into the facts and the weeds here.
Mm-hmm.
But I think legally, if you just ask me as a legal question, who I think probably would have the best legal argument, or which position, which I think would be better situated in this particular litigation, then I would say based on, I think Katie just has to win one of these things, right? She just has to, if she wins on personal jurisdiction, win. If I win on the motion for summary judgment that you haven't stated a claim, accepting everything is true, win. And if I went for any of these other ancillary stuff that we haven't talked about, she still wins. So, there's still a lot of hurdles that I think this case has to, her losing this motion doesn't stop her from actually still winning the case. But I do think it all is going to turn on James. If they find James to be a public figure, I think this case then goes nowhere. I think it ends at that point in time.
I think that's quite possibly right. But I think I'd just like to recite all the things that have happened since the motion to dismiss.
All right.
Just to show you how off the rails this has gone. So number 17 on the docket was the motion to dismiss. And then the next thing that happened in
hold on. But before you do that, so what was it? Number 14 you said was on the motion to dismiss?
17.
So what number are we up to now?
43.
All right, read them out.
Yeah.
Damn.
So 17 is the motion to dismiss. And then 27 was the response. Then 30 was a precipice. That's more shit has happened stuff. Then 33 was the reply. Then 38 is another precipice. We really love the word precipice. It's like our favorite thing in the world. Then we had the motion for the status conference. Then we had, there was I missed one because there was the request for the SIR reply, which I missed at some point. And now we're on to this. It's like, it just keeps ending and never ends. There's so many things in this. Why is it going on forever? So many declarations. Kim Fulmer, and we have Lorianne, and we have so many people. And the last thing we had was 221 pages of glory. I read it all on stream with commentary. It took me 4.5 hours. I did appreciate Emily Baker, man. Emily D. Baker. She seems to like the middle initial, so no intent to disrespect. Emily D. Baker. She says, well, I'm not going to read it all. I'm like, yes, you are. Because she did. She read it all. Now, it only took her 2 hours because she didn't have a commentary on top. But it's like, I'm not going to read it all. I'm like, yeah. She streamed for like 2.5 hours to get through 221 pages. I had additional commentary on top of it, and it's just like, yeah.
I like how they mentioned the coverage. They were like, Emily D. Baker and others. They're like, oh no, and others have covered the case. I'm like, oh no, I just want to get that name in there. I don't know. It's
I've also got to wonder how Katie Joy is paying her lawyer. I mean, with all due respect, because Katie Joy has a channel of 150,000, and she's probably getting some amount of revenue, but this is expensive. I mean, especially what Brown was filing. I mean, we're talking some serious change being expended. So I wonder how Katie Joy is paying her lawyer a little bit. Because, Toddy presumably has the backroll for it, but Katie Joy, I'm not sure what she's offering, but
Okey-doke. Well, let's what regular you're talking about? Let's say even on a cheap end, $250 an hour. I'm talking about that's incredibly cheap for a lawyer of that magnitude.
For this guy with this experience, he's not charging $250, but sure, let's go with that.
Let's just go at $250. And you're talking about the 126 pages of now him going through emails and him doing this, and every 6 minutes, and you're talking about people from the firm going through emails and having late night conversations with people who are writing your 1,500 page odysseys, and and Twitter, and look at this. I'm talking about. You got a lot of hours, I think, are going into this case. So it just doesn't make sense.
135,000 subs. I was in the ballpark. Give me a break, but fair enough. Yeah. So fair enough. And on that note, I'm very pleased with the growth of my own channel. I think we gained 250 subs the last time we did a live stream. That was cool. Really plus. Yeah, I know. It's nice. Not bad for 250 subs when we did that very late night. We started at 11:30. We didn't end till 3:45. It took us to do that live stream where we read through all that stuff and with
Oh
commentary.
yeah, I don't know. I don't know how
I'm hardcore, man, hardcore. So those of you who want to watch 4.5 hours of me watching or reading the documents with some commentary, it's an available option. If you just want to read the reading, Emily got through it faster, and not all of it was spent on the top. So she's probably only spent maybe an hour and a half actually getting through it all, but she just blitzed read it. If you want some commentary, then you have to come to Uncivil Law. But yeah.
But that's what happens with these cases, though. It seems like these YouTube cases, the people who are involved, especially I think now our genre is a little different, where we're covering cases of people who are in YouTube. So now those people it's like it happened with me with the non-set case. Those people who are friends with that person and the person doesn't like the coverage. It's like they attack you. Next thing you know, you're in the lawsuit. Hey, this guy's talking bad about me. And the same thing's happening with Emily. Hey, look at Emily Baker's talking bad about me. It's like, okay, but what does this have to do with this motion to dismiss for personal jurisdiction?
Yeah,
like how are we linking Emily Baker to you have it? It just doesn't make any sense. I just don't understand it.
Fair enough. We'll answer a couple questions here because there's a couple questions piling up. Jen Gerard asked, "I think your stream was the longest in history the other night." Nick Ricada definitely does some long streams too, but fair enough.
Oh, yeah.
Question: are you saying if someone's a public figure, it's okay to call them a murderer? Well, it depends on a lot of the answer to every legal question is it depends, and this is no exception, because it depends a little bit on whether or not you are making a statement of fact and whether or not it's understood as a statement of fact, whether it's understood as hyperbolic, an exaggeration, whether it's understood as an opinion based on other things. So it depends a lot on context. But public figure, even assuming that's a factual claim, when you're a public figure, to get to mouse to the truth, you have to show either one, that it's false, or that you recklessly disregard the truth. And based on the evidence that Katie Joy had available to her, it's not clear to me that even James can get there for that standard. But I think James has arguments, so I think he might win this. But I think Katie has some decent defenses. In large part because specifically of the amount of research that she did. Again, Tottie's own harassment claim is somewhat undermining the defamation claim. The amount of research she did allows Katie Joy to say, well, this is an opinion that's well informed by a extremely wide view of what's happening. So,
well, hold on. Let me look to see what exactly did she say about the husband killing the wife, because some people I've heard everything from she said he killed her to it was implied, and I think that's an interesting difference.
She said it's all been paraphrased and referred to. It's never been.
It should be in the complaint directly. No? It should be in the complaint.
It was, but maybe it was. We can go back and check. I don't know if it was actually quoted.
The complaint should allege that defamatory statement, because I've only reason why I'm saying it's not clear whether if she said this guy murdered his mom, right? That's different. Yeah. That okay. Now we're talking about actual malice. There's no way that you can know that was true. Show me how you know that's true.
Well, there's this quote in the complaint. He stole money from his dying mother, took out loans in her name while she's sick and ill. There's this quote about he stole money from a dying mother. This is in the complaint.
All right, because usually in the complaint they'll have the quotations about, because defamation about what exactly you said. So is there any quotations about what was said that's being interpreted as?
Paulson was saying it. Paulson was saying this about James.
All right, so what did she say?
Apparently, quote, he stole money from his dying mother, took out loans in her name while she was sick and ill.
Okay.
And on a different video, quote, he stole money from his dying mother. Okay.
So he stole money from his dying. That doesn't seem defamatory. That doesn't seem to qualify as, as overcoming that standard just by that statement. What's the and what evidence did she have for that? Oh, she had the
They're referring to specific videos. They're referring to specific dates.
Okay. But that I don't see that does that rise to defamatory?
I mean, it's arguable. It's arguable either
Yeah.
way. And I think it's arguable for Toddy. I think it's arguable for Katie.
No, this is against James though, right? This is
Oh,
against James.
apologize. I misspoke.
So he killed his dying mother. I would have to see the source material because now with that, I think it's 50-50, but I would still think like if she got that from a court document.
Yeah.
You know, and here she's alleging this too. She's saying, stole from his dying mother. Those are, I don't know. I don't see actual malice with that.
A motive. It's like it's a motive statement, right? This was his motive behind what he did. So that's kind of opinion-esque. But I mean, again, I would have no trouble as an attorney arguing either position. I would argue James' position, and I have no problem. I'd argue Katie's position, and I have no problem. Either position's tenable, either position's arguable.
Well, hold on. The one thing, but I'll draw it back to Tucker Carlson, what he said about her, committing what he said is actual extortion, right? The facts are undisputed. This was actual extortion. The context of which it was said also matters too, in terms of what is this a channel that people would also believe would yes. So Carlson got off with that. Mattles got off with that. Is this commentary or is this news? Are she laying out facts, and would a reasonable person believe that what she's saying is true?
The Tucker Carlson lawsuit in response is pretty good for her because she's providing in the context of reporting. I mean, she calls herself a journalist, and that has a lot of different meanings. But again, she's doing a lot of deep dive research, whatever you might think about her conclusions, one way or another. But I think both positions are arguable. Like I can argue this position from James's position, so I could argue James's position, and I can argue Katie's position. I would feel comfortable arguing either position because I think both positions are workable.
Well, James, I think if you get to the actual malice standard, and then all this research,
well, that would be the ideal for Katie is to make him public figure, because if he's public figure, we have a lot more problems. I think if I'm James's lawyer, I can prevent that from happening. I think I can win that argument. And even if I can, though, then turning back to Katie's lawyer, I think I can win on that standard too. But I think both are workable. It'd be fun to try. It'd be fun. It would be a fun moot. It would be a fun moot court. That's where when we used to do these. Did you ever do moot court or mock trial?
Yeah, I was on moot court.
So yeah, this is great because when I did moot court or mock trial, like you didn't know what side you were going to be on any given round. Like you didn't know which side of the argument you're going to be on. This would be a fun one where I was like, I don't know which side of the argument I'm going to be on, but I think I can win it from either position. Either position. I think it's winnable. It's a good mock trial.
But that's the way they always do it. Yeah. This is a good mock. This would be a mock. I think a lot of people don't understand too is that let's say even we get past this and we do get to the merits.
Yeah.
I think you also then have to go into what research, because that's what they'll get into. What research, how did you find this? Why are you making these statements? Is she implying something, or is she actually saying something? Because if something is implied, they usually know that usually doesn't go. It's actually the words have to mean what they say, and things of that nature. But at the end of the day, I want to see how the judge responds just to the amount of filings, because that's 122 pages they just had to read through, right? Some poor clerk had to read through 122 pages and has got to give that to her judge in some workable manner. And the first thing he's going to say is he's going to look at he. This judge, I keep saying he. This judge is going to look their clerk in the eye and say, tell me what does this have to do with personal jurisdiction?
A fair question from Amputee, and one I'm happy to answer. How can both of you talk about this without even checking what happened? The evidence is easy to find. And I'll speak for myself, and Nate can speak for himself as he pleases. But for me, I'm trying my best to put myself in the position of a judge. And I don't think at this stage of the proceedings, the judge is going to look at any of these videos, because she doesn't need to decide the issue before her. There's more enough information. Now, she might have to look at it later, but I'm trying to put myself in the position of a neutral arbiter. And that, of course, isn't to say that my position as a neutral arbiter is the same as what the judge will do, because different people think about that differently. You've seen that between the way I cover the case and how Emily covers the case. We think about things very differently. That's not a slight on Emily. She thinks about things differently. It's not a slight. We're different people. So we react to things differently. She's well educated, she's well informed, she's knowledgeable, she understands the law. We still react to things differently. We care about things differently. And that's why I like listening to her content so much, because it helps keeps me in check to make sure that I'm thinking about things in a not, checking my own biases. I love listening to Emily. But one of the reasons I don't listen to the videos or watch the videos is because I don't think it's what the judge is going to do at this point and not for some point. So that's just how I react to things. And you can speak for yourself to the degree that you wish.
Yeah. Well, now I have seen some of the videos and I have looked at some of the things that some of the other outside information that people are talking about. So in terms of that, are those statements maybe yeah, I think if they were, but whenever you hear me talk about this case, I can only talk about the things that are within the box, right? And the standard that we're talking about evaluating this under. So my understanding is at this point in the case, that's why we keep saying it. Remember earlier we kept saying, if everything that she said is true, everything that she said is true, all these things are assumed to be true. That's because we're working off the information the court is going to make the decision off of. Yeah. And we're assuming, just like the court is bound to do, that the facts are true. So we don't need to see the video at this point.
Yeah, exactly right. At this stage of the proceedings, there's no reason for the court to look at the videos, because the court, again, at this stage of the proceedings, the court by law must assume everything Toddy says is true. So why look at the videos? Because everything she says about them must be true. There's no reason to look at them. It must be true. There's no alternative.
So we're talking about the case in those terms, and
we're looking at the case in saying. So I'm not going to look at the videos because exactly.
So we agree. There may be stuff out there that you guys know about that we should know about that'll help us make determinations on the merits of the case. But at this point in the case, at the motion to determine the motion to dismiss, even if you show me these horrible things, it's just going to. I'm already accepting everything that Toddy is saying as true.
I just fundamentally disagree with this idea, because at this point that we're at right now, and with all due respect to Jennifer P., we don't need to watch the videos, because the only issue we're trying to decide at this exact second is personal jurisdiction. We don't need to look at the videos because we can look at the pleadings. Everything Toddy says about the videos must be true. That's where we're at. Everything Toddy says must be true. That's the entire point. We don't need to look at the videos because whatever Toddy says about them must be true.
She's saying the worst possible thing about it, right? She's saying the worst possible thing about those videos, right? What me watching the videos, how does that change the fact that what Toddy's already said is worse than the video, right? How could that make it? How could it change that for me?
Right. Whatever Toddy says must be true. I mean, that's exactly the mindset that we're in. So why do we need to watch the videos? Because
matter of fact, watching the videos
is like, well, that must be what the videos say.
But actually watching the video may even hurt her side, because then I can evaluate it. Says, the way she's describing this is wrong. I wouldn't describe this as X, right? I wouldn't describe this as B. But
I'm thrilled for how you would or would not describe it, but how would Toddy describe it? That's all I really care about at this point, right? I mean, that's the legal standard. It's easy. The entire point of the motion to dismiss, the entire point is assuming everything Toddy says is true. Does Toddy have a case? That's what we're trying to determine at this exact second. And I think, as I've mentioned many times, Katie Joy Paulson has some very interesting defenses on a legal matter, because we don't have to dispute the facts, because we can't. We can't dispute the facts if we're Katie's side. She has some legal arguments, however. As a matter of law, Toddy is a public figure. As a matter of law, James is a public figure. As a matter of law, we meet the negligence threshold given everything they say is true, et cetera, and so forth. So I mean, whatever Toddy says is true. That's the legal standard. And it's like, this is again why I was so frustrated with the motion to dismiss, because I'm like, oh my God, why? Because I think there's some workable positions there.
And a lot of people don't understand when we're talking about this actual malice question and stuff like that.
Yeah.
It's going to be a matter of law for a judge to decide. In the case of let's say a motion for summary judgment, they haven't alleged enough to overcome actual malice, or it hasn't. So that's how we're talking. That's how we're talking about the conversation. But again, it's
Melissa K asked the question. Wait, everything Toddy says is true. Laughing my ass off. Yes. Let's try this again. Yes, everything Toddy says is true because of the posture that we're at. We're at a motion to dismiss. We must, by law, assume that everything the non-moving party says is true. The person that's asking for the dismissal is Katie Joy Paulson. By law, we must assume everything Toddy says is true. Yes, everything Toddy says is true. Everything Katie says is false. That's the legal standard where we're at. Yes. Yes. Oh, man. Wow. Oh, man. This is and yeah, it's like, and then again, it's like we're exactly where we said before. It's like, yes, even then we think that Katie has some workable things because we don't have to dispute the facts. That's the point. Every fact Toddy says is true. Period. End of discussion. That's the law. So given all that, can Katie win? Well, we had some interesting ideas. As a matter of law, public figure. As a matter of law, we meet negligence. As a matter of law, underlining truth, and so forth and so on, right? So that's that. No lawyer will disagree with this. None. Because it's not an issue of dispute. It's crystal clear. Yeah.
Yeah, and the reason why the court and the reason why the court takes this posture is, again, it's just by assuming that every best possible inference and everything for the plaintiff, then you can clearly see if it's legally insufficient to go forward. Obviously, the statute of limitations was the argument that I was using before, is the fact that even though no matter, by assuming everything in the complaint is true, then if the statute of limitations is run, then it will be dismissed solely on that point. And that's what's going to happen with the jurisdiction. If it's going to be dismissed, it's going to be dismissed solely on the point that there's no personal jurisdiction.
No. And SB asks a fair question. So there's no dispute KJ is considered a public figure as well. No, that's not true, because what public figure is a question of law, not a question of fact. You can say, here are the facts. Here's what KJ did. Here's the videos that she made. Here's what she did. Here's all the facts. The question of public figure is a matter of law. So you can dispute that. You can't dispute the facts as to what Katie did or did not do. But the question of public figure is a legal question. That's a legal determination. So yeah, that would be proper for analysis. And it would be the same way. Like at least Toddy could theoretically argue that she's not a public figure. That's a legal question. Or she argues that she is a public figure. That's a legal question. And Katie can make the same legal questions. But the facts of like who did what, when, where, how, it's like, yeah, the factual questions are set.
But one thing, even about the question of whether KJ is a public figure or not, would actually honestly be irrelevant, right? Because it's always about whether the plaintiff is a public figure in this particular in this case.
Right.
So if she's a public figure or not, that would be irrelevant in this particular manner. But also, if they do go after and say that KJ is a public figure, I think that hurts their claim even more. And the reason why I think that hurts their claim is that James is on videos that got millions of views, right? KJ is doing videos that get thousands of views. Right. So if you just talk about the audience that knows these people and that, the reach of their influence, then I think it'll be hard to make the claim that James is not a public figure and KJ is a public figure when they're entertaining in the same space. You know what I'm saying? Right. And you're just talking about, how many people they reach, how much influence do they have, with people, is a person more likely to know who Katie Joy Paulson is versus Toddy Westbrook's husband. Then I really think you have a problem with the public figure for James. If you just want to compare them to Katie Joy and say she is a public figure.
Yeah, and there's legal questions to be asked. This is an interesting question, at least to me. Karen Nash Collins asks, as a matter of law, can a person accuse another person on social media of killing his mother by removing oxygen for money. Those are some serious allegations. Again, it would depend on a whole host of things. And as to what Toddy says is factually correct, we would take as true, definitionally. The legal conclusions we would draw are up to us. So, and also whether or not there are valid opinions or whether or not those are facts and the public figure and all the rest of us. So it would depend on a whole host of things. But at this stage of the proceedings, at this stage of the proceedings, we're just trying to determine personal jurisdiction. So we're not even trying to determine defamation. This question is going to defamation.
But let's assume that's true. So let's say that's true. Let's say that was in Toddy's lawsuit. Let's say we're assuming this is true and this was defamatory. Put the other comment back up.
Sorry. I'll find it again. Give me a second. It's going to take a second.
Because I'm saying let's assume that was true, and let's assume that's even in the complaint, right? Let's assume it's true and everything. Let's assume all this is true. But if the court doesn't have personal jurisdiction over Katie, it's irrelevant. It's irrelevant, right? If the court doesn't have personal jurisdiction over Katie, then this court's going to dismiss the case, and this won't even matter because they would have to file it in the jurisdiction that has personal jurisdiction over Katie. So that's why this, which you're putting, it matters in the case. Yes, of course it does matter.
Yeah,
but it doesn't matter.
It doesn't matter for jurisdiction
of what we're talking about, because even though this is true, does this court have the right, and the privilege to make Katie pay for it?
Right.
If this court doesn't, then she has to go to the court that does.
Yeah. So these questions that Karen is asking, as Nate points out, are beyond our current scope, because we're at the moment. And I don't blame you, Karen, because we've all, including the lawyers involved, including I think the clients involved, we've all forgotten the plot. The thing that we're trying to decide at this exact second is personal jurisdiction. So whether or not someone said this and what does it mean, if it's defamatory or anything else, it's like it doesn't matter, because of the question we're trying to solve right this second is personal jurisdiction. And I don't have to figure out the answer to this question to figure out personal jurisdiction. It just doesn't matter for the present purpose. Sufficient minimum contact. That's the only question we're trying to determine. The simple way of asking this question is, did Katie do enough in Washington for Washington to judge this case? That's what we're trying to determine. That's the simple version. Did Katie do enough? Did Katie do enough? And to answer that question, like we've analyzed that in some depth. I've done prior research on the case. I did 3 hours of Westlaw research to try to determine this to some degree, and I barely scratched the surface of it.
Oh yeah,
I need to do way more research as a judge if I were trying to figure this out for real. But the sufficient minimum context. Did Katie do enough? That's the only question we're trying to solve at this exact second.
And it really comes down to a determination of, usually these things come down to a determination of, would it be fair would it be fair and would it be reasonable to haul a defendant into a court into a Washington court from another state. So let's say if Katie lived in New York, right, and real across the country, and Washington, and this lawsuit was going on, is it fair that Katie has to travel from New York to Washington State to defend herself in a Washington court? And usually they ask is, would a reasonable person think that their contacts, what they were doing, would subject them to that jurisdiction? So I think there was the Burger King case in which Burger King was like, well, our headquarters was here, and the place was here in Florida, and they were like, well, no, because your minimum context is the fact that you have a contract there, that that all this stuff is happening, that if somebody doesn't pay you for a burger down here, then you can sue in our courts to get your money for your products. That's what we're looking for. So I don't think I understand what Saltsy's doing. He's making a great argument with what he got. He's got Lorianne, somebody who lives there. If I was Saltsy, I would have used his argument, but I don't think it's enough to overcome the hurdle of personal. Kurt thinks it is, but I do not think it is. Go ahead.
Well, I think I don't personally think it is, because I'm likely to go the other way. I'm just predicting what this judge will do. So if I were the judge, I agree with you. I'm just predicting what this judge is likely to do. So
okay.
Yeah, that's my split. Like, I don't think the judge is going to agree with me. That's what I think.
All right. That's fair
But
enough.
yeah, this question from Linda just shows the frustration sometimes of legal education, because you try to make it clear and people still don't understand what you're trying to say. So yeah, Linda asks, why are they assuming Toddy's side is telling the truth? Because we have to by law. It's very clear. It's rigged, corrupt because Jeffro L. Star is evil. No, it's because in a motion to dismiss, you must assume, as a matter of law, that everything that the non-moving party says is true. That's the entire point. Assuming everything the non-moving party says is true, do they have a case? So it has nothing to do with Toddy versus Without a Crystal Ball. This standard was established long before we mentioned either of these parties. So yeah, Without a Crystal Ball is moving to dismiss. So as a matter of law, we must, by law, assume everything Toddy says is true. That's the legal standard. And incidentally, this will work the other way around, because assuming this case continues, there might be an answer. And Without a Crystal Ball might make counter accusations. They might bring their own, they might bring their own things. And then in that situation, Toddy might move to dismiss. And if that ever happens, if Toddy moves to dismiss a theoretical action from Without a Crystal Ball, by law, we will assume everything Katie Joy Paulson says is true, because that's the law. We will assume everything Katie says is true in that situation. That's the entire point. So yeah, I don't know what to tell people. Yeah.
No, it's difficult because it's somebody hear us say everything that Toddy's saying is true, and then it's an emotion. What are you talking about? No, she's a liar. No, yeah, that may be true. She may be a liar. Everything she may be saying is false. That's
definitely not what we're trying to cover right now.
In trying to understand, if Katie Joy can get the case dismissed legally, is saying yes, if everything she's saying is true, is it still legally sufficient to move forward? And that's what the judge is going to say, is looking at now. So that's why we keep saying all of these filings make no sense. When Katie Joy says that's not true, right? What Toddy is saying is not true.
Yeah,
that's irrelevant, right? Because we're not at the stage where that should even be challenged. We're assuming it's true, and I want to make sure we also mention that it's really at the point that when we make that claim, it's at the point where the trial hasn't started yet. The case is really at the most basic preliminary stages. We're seeing if she has a case to move forward. That's all we're looking at. We're not looking at the evidence to see the value of the evidence or the fact finder. We're just really preliminarily asking, does she legally sufficiently have
one issue at a time, one question at a time? We just do this very methodically. The law is nothing if not methodical. Just look at this one issue at a time, one case at a time, one question at a time. Just deal with them in sequence and deal with it. It's fine. And we'll deal with the rest later. And Nate and I have been talking a little bit about where this all ultimately goes at the very end, because we've been talking about defenses and stuff like that. But that's different too from where we are. But yeah.
Yeah, talking about those defenses, they could have filed them in this motion to dismiss. That's what we're saying. That's what we would have filed in this motion to dismiss, because it's be evaluated under the same standard. Yeah. And when there's a motion for summary judgment, it'll be evaluated under a similar standard, assuming everything the plaintiff says is true, go forward. So
Natasha asked, does the minute order for them to come before the judge to sort out the chaos, can that be a determining factor? Probably not in and of itself. It's unlikely that anything that happens at the conference will be a determining factor in jurisdiction. I mean, I suppose if one of the sides just openly confesses before the court or says something, it's possible, but that's unlikely. Based on the paper, the purpose of the status conference is literally where are we? Where are we? What's going on? Let's ground everyone in a mutual reality. We get the parties before the judge, so we can all say where are we and ground everything in a common reality. That's the purpose of the status conference. Could it happen? Yes. Will it happen? Probably not. The status conference will probably be some version of, first of all, they have to decide whether or not there will be a status conference, because apparently that's a question for some reason. So they have to have an argument about whether or not there will be a status conference. And then when the judge grants the status conference, because it absolutely should happen for sure, when the status conference happens, then the judge will basically be like, okay, where are we? What's going on? What is the status of things? What's happening? Make sure everyone's on the same page. And if I'm the judge, at least myself, I'm like, yeah, okay, I'm going to ignore a whole shit ton of what you guys have been filing because I don't care. I'm trying to decide the personal jurisdiction issue. So we'll just make sure to calm everyone down, probably file another minute order that says you guys can't file anything more because I've got more than enough to figure out the issue before me, personal jurisdiction. I'm going to go research the law and figure that out for a while. So, yeah.
I think you mean minute order. You like minute order. I'm like, oh,
it's supposed to be minute. It's supposed to be
minute.
minute.
I'd always still call it a minute.
Every lawyer I know pronounces it minute. Every lawyer I know pronounces it minute. But it's supposed to be minute. The word literally means small.
Interesting.
Every lawyer I know pronounces it minute. Every lawyer is wrong. It's supposed to be minute. It's a small thing. Minute, small.
Yeah. And that makes total sense. That makes total sense.
No joke, right?
But I've even heard judges call it minute.
Yeah, I know that. I understand that. Yes, everyone I've ever heard, including judges, pronounces it minute order. I understand this. The word is obviously supposed to be minute, as in small. That's obviously supposed to be the word. So I'm here to try to bring back the entire goddamn legal profession back.
Nah, it's going to be called minute orders for the rest.
Okay, it's
of
a minute order. Fuck it.
Time.
It's a minute. Fuck it. I can't change the law.
At the time, you are 100% right, but that's gonna be a Jeopardy question. What's the name of this order by the court? They're going to literally put minute order up there. People are going to read it. Minute order. And yes, crazy, man. Great. That's a hell of a Jeopardy question. A hell of a Jeopardy question.
Yeah, I'm well aware that everyone, including the judges, pronounces it minute, but no. Yeah.
So no. At the end of the day, for this case, I think if for the motion to dismiss, we were at. I think if I don't know. I think even at this status conference, the question was about jurisdiction for the status conference. I just don't see it. It's possible, I've seen weirder things happen, but it's just, if, the court, if this is all in furtherance of this motion to dismiss, unless I see Katie Joy flying into Washington and being served at the conference or something like that, personally served, and then you got to maybe have an argument about that. I just don't see it. I don't, maybe I got to hear Emily's argument. She has to have some legal reasoning behind this because it just does seem a little foreign to me that you would get personal jurisdiction for participating in a motion to dismiss for personal jurisdiction, right?
Yep.
It just how then can we get through this? If I participate, then there's jurisdiction against me. Then then should I ignore the order? Well, but he's requesting it though, right? So he's requesting it.
So we're expecting a filing from Salts on the 27th, which I assume will be super interesting because I assume it's going to incorporate some of the stuff. It'll be interesting to see how Salts responds to this latest precipice, because I think it's quite possible that Lorianne didn't give Salts all the information.
You think Lorianne? So hold on.
I think it's quite possible that Salts heard what he wanted to hear and has been led up the garden path by a banshee screaming into the night. Yes, that's what I'm going with. Yes. Hold on. The siren song. The siren song causing me to crash upon the rocks. That's basically what happened. Yes.
Hold on. Last time you updated me about this case, you were saying that the Lorianne thing was damaging, right? You even used the words damaging to KJ's piece, even though we agreed it was woman scorned.
Lorianne's credibility is going to zero.
Now all of a sudden, Lorianne
because Brown had a fantastic rebuttal. I mean, Brown had because Lorianne wrote this 1,500 word thing unprompted, just wrote it about here's everything that happened, and all the affidavits or declarations that Brown prepared for Lorianne were well in line with it, and Lorianne didn't object to it. So yeah, Brown looks good to me. I have no objection. Whatever other objections I might have, I have no objection to how Brown treated Lorianne. I read it all on stream. It all looked fine to me. There was no conflict. It's all fine.
So Brown cleared it all up.
Yeah, as far as I'm concerned, yeah. So there's three options that I can see on the table, and maybe we'll come up with other ones, but there's three I can see. Salts had everything, and basically suborn perjury, which I don't think is
Nah,
true.
that's
And we'll put that
yeah.
past.
I would,
Salts has everything and also has other stuff that somehow makes the declaration okay, which seems unlikely given how much stuff there is that Brown disclosed, that Salts could somehow have other things that makes it okay. But I it's at least tenable. And option number 3 is, and the most likely to my mind, is Lorianne basically sold Salts a story, and Salts wanted to hear a story, and Salt, because he filed like 24 hours after Lorianne contacted him. So my working theory is that Lorianne sold Salt's a story, and he bought it because it was what he wanted to hear, and kind of made a boo boo. That's my working theory of what happened.
You know, and I can see that happening if the person's telling you exactly what you want to hear too. Like, all this is true. She does this. She does this. She does this. You know, and then now, but then it makes me think. That means that rebuke of when what's her name, Katie, when she said that Lorianne wasn't her friend and she barely knew her. Would that be the catalyst to all that? Because it just seems weird for my friend, my real good friend, to go from A to B where she's filing affidavits against me in court. Now it's just that's
it might be. I think your friend Katie Joy has been opening her mouth in direct contravention to her attorney's advice, and we know her attorney advised that because we saw the instant messages. Like when Lorianne contacted Katie said, "I can't talk to you. I contact my lawyer. I'm not allowed to talk to you." Katie did exactly the right thing.
Yeah.
When in that situation. Unfortunately, it seems that Katie has been opening her mouth on YouTube and streaming, and it seems in no small part because Katie had a stream in which she threw Lorianne under the bus. Lorianne then contacted Salts. So it seems that there is some strong likelihood, in my humble opinion, that Katie might have undermined her legal position by opening her mouth. Not that any lawyer could have possibly seen that coming, because it's not like every lawyer on the face of the earth would advise you to keep your mouth shut because you might open yourself up to possibilities. Yeah, but it seems that Katie may not have done that, and by not doing that, might have exposed herself somewhat.
Listen, I've been very critical of that side, of Katie's side, and I'll just say it. I don't know if I would have even played this game if I was Katie's side. I just think I filed the motion to dismiss for jurisdiction and an attack of defamation, and I think I'm all good. I think I got a hell of a defense. You know, the judge right now, we be talking about the case. What do we think the case is over or not? You know, right now, you know, even then you get another bite at the apple. A couple of strategic misses, I think, is happening with this Katie Joy piece. Is the first thing is, by not attacking the defamation, you miss the opportunity for the court to look at it for the first time, be able to evaluate it, and it gives you an idea too of how strong you think the court thinks these things are. Right? They have they can go, you know, they can move forward, and it gives you the first bite at the apple to get it thrown out. Then you go through discovery, and then you get all that, the back and forth, and then you get another bite at the apple again with the motion for summary judgment. So 2 times you'll see what they hand, and then 2 times you'll go through discovery, and then you'll say, well, hey, even if everything they're saying is true, they're going to lose. So that second bite of the apple is also valuable, because at that point in the case can be thrown out then. And then if you miss it again, then you go to trial. Then you get one more chance, right? After they present their evidence, you get one more chance to say, hey, listen, everything they presented, even if true, doesn't meet and then, you know, the judge will make the determination, and then you go forward through that. So that's what we're saying. This was by not filing and fighting the motion to dismiss, by not fighting based on failure to state a claim, she's missed the opportunity to end the case now. So because those opportunities are rare, you know, you only get a couple of them. And this is one valuable time that she could have ended that, even if she loses on the personal jurisdiction, she could have still ended the case, and she's missing. And that opportunity, I don't know why her attorney is missing this opportunity. I don't know what it just doesn't make any sense. But this is a very, you know, especially if you're talking about you're paying your attorney, then you're paying your attorney to end the case as soon as possible if you're the defendant. right? In the best possible way.
One would imagine, right? One would imagine, and all this fighting between the attorneys is increasing costs for both sides. It's not productive.
You don't need it unless, and again, Katie's paying for that.
Yeah,
why am I
no
paying
joke.
for you to clear your name? Is that on a huff right there? Are you taking care of that? Because I don't care if they think you're a bad guy, but what I do care about is keeping costs low and getting great legal, getting great service. If they think you're an SOB, I'm paying you to take those hits. I'm not paying you to put 122 pages.
I mean, to some degree that's true, but it's also important what your own attorney's reputation is, because that matters to the judge too.
Of
if your
course.
attorney looks the fool, that's going to undermine your case too.
But you can do that at a hearing when you're there in person, because you're probably going to have to be there in person. We're trying to save money here also on the thing. If I can get it kicked out of the motion to dismiss and avoid filing all this stuff and spending all this extra money, then of course I just get it kicked on a motion to dismiss and call it a day. Why do I need to follow responses, right? Everything you're saying is true, and even if that's true, you don't have a case. What more? I don't care.
That
what
was the legal standard. Yeah, that was the legal standard long ago in the far away. Yes,
you save money, you save time, and you get an extra bite at the apple to get it thrown out. I just don't see why somebody would take. It's like going out on two strikes.
I'm just waiting for Kat to start following some things in this, and just waiting for this to become a triple thing. And maybe it becomes the YouTube lawyers. Maybe you or I will start a fight, and somehow we'll start following some things in this, or me and Emily. I don't know. But then they
put Emily in the lawsuit too. They put Emily in this lawsuit.
Why give her a little shout out? They give her a little shout out. I felt a little unloved. No shout out.
You're others. You're part of the others. Hold on, you're one of the others.
I think I'm worthy of my own mention. Am I not? What happened to your camera, Nate? Nate's camera killed. Oh well. Well, with my friend Nate the lawyer apparently being kicked off the stream due to no fault of my own, I will end the stream myself. Can I ask you please to subscribe if you've not done so already? I've been very pleased with the growth of this channel, and I'd very much like to get some growth. And Nate's back.
Yeah.
Nate's back. Yeah.
Sorry.
I was going to end the stream.
That just happened to happen.
Because you disappeared off the face of the earth.
But I'm here. But listen, we can end it. We're 2 hours in. I think this was good enough.
Fair enough. Yeah, 2 hours in. Yeah. So if you like the stream, may I be so bold as to kindly ask you to please subscribe. It's free, and you can always change your mind later, and it helps you get access to this quality legal content. And also, please remember to subscribe to my guest, Nate the lawyer. He's fantastic. He does some wonderful videos as well and provides a different perspective, helps keep me in check. It's all valuable. Subscribe to both of us. We all appreciate your love. If you've not done so already, please remember to hit like the video. It helps with the engagement. It's awesome. And did you know, for a mere 99 cents, you can become an uncivilian? It's true. The Streamlot bot has been reminding you from time to time, if you hit that link, you'll become an uncivilian. You get access to batch records. On this upcoming Tuesday, you'll get access to our members only live stream. You get to ask questions. Ooh, very exciting. And you get access to other things, including my love. That's the most important thing of all. I wish to thank my guest, Nate, for being here. It's been awesome. Till later, my friends. Cheers and goodbye.